Welcome back, Love Nation. This is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. We're going to get straight into part 4 of this dismissal document that came from Justin B's attorney. There is a lot of juicy details in this filing. Again, this is part 4. Leave your comments below, and let's just get straight into this mess. Part B. Blake Lively made defamatory statements herself. Separate and apart from the actions of her agents, Blake Lively made defamatory statements about the Wayfair parties in her individual capacity. Specifically, the FAC alleges that Blake Lively told the New York Times that the Wayfair parties engaged in, permitted, and or failed to prevent SA misconduct and orchestrated a smear campaign in retaliation for Blake Lively's purportedly protected disclosure thereof. Blake Lively also falsely claimed to the New York Times that the Wayfair party's agreement to the 17-point letter was proof positive that SA harassment was endemic on the film set, and that the Wayfair parties had responded to Blake Lively's complaints about purported SA harassment by plotting to destroy her reputation. In short, Blake Lively told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for SA complaints, with the knowledge and intent that the newspaper would publish that false story. The fabrication made by Blake Lively are further detailed below and exhaustively outlined in the FAC. Section 2. The Wayfair's party's defamation claim is timely. Blake Lively's statute of limitations argument is meritless. Specifically, Blake Lively contends that the defamation claim is a time-barred under California and New York law by a 1-year statute of limitations. A review of the FAC makes it clear, however, that the earliest statements at issue are those of Ryan Reynolds in July of 2024. Although Blake Lively implausibly argues that the defamation claims arises from the 17-point list presented to Wayfair in or around November of 2023, that is wrong. Although certain of the Wayfair's party's claims implicate the 17-point list and Blake Lively's conduct during production, the defamation claim arises from statements made between July of 2024 and December of 2024. The instant action is, therefore, timely. The defamation statements are not privileged. Section 3. Blake Lively also argues that Wayfair's party's defamation claims fails because the statements at issue are protected by 3 overlapping privileges: the litigations privilege, the so-called SA harassment privilege, and the fair report privilege. Motion at 1521. But as detailed below, none of the 3 privileges insulate Blake Lively, not only as a legal matter, but as factual one as well. Section 4. The litigation privilege does not apply. The litigation privilege codified in California Civil Code 47B provides that a publication or broadcast made as part of a judicial proceeding is privileged. The privilege applies to any communication: 1. Made in judicial or quasi-judicial proceedings; 2. The litigants or other participants authorized by law; 3. To achieve the objects of the litigation; 4. And that have some connection to or logical relation to the action. See court case cited. The principal purpose of the litigation privilege is to afford litigants and witnesses the utmost freedom of access to the counts without fear of being harassed subsequently by derivative tort actions. A communication protected by the privilege must be in the furtherance of the objects of the litigation. The communication must be connected with or have some logical relation to the action. Blake Lively's litigation privilege argument is predicated on the false premise that the statements at issue were made in legal proceedings or as part of legal proceeding. But that is simply not the case. The Wayfair party's defamation claim against Blake Lively arises from her statements and those of her agents to the media, WME executives, and others from July to December of 2024. The FAC does not seek to hold Blake Lively liable for even otherwise defamatory statements actually made in the CRD complaint or lawsuit. For the litigation privilege to apply, the logical relation between the communicative acts and the litigation must be a functional connection. See court case cited. This has been interpreted by California courts to mean that the communication must function as a necessary or useful step in the litigation process and must serve its purpose. Thus, such acts as filing a lawsuit or, in many cases, sending a demand letter are protected. Communicating with the public or the press is not, even where it advances the litigation by rallying the masses. Indeed, the litigation privilege does not protect litigating in the press. See court case cited. Such as an extension would not serve the purposes of that privilege. Indeed, it would serve no purpose but to provide immunity to those who would inflict upon our system of justice the damaging which litigating in the press generally causes, poisoning of jury pools, and bringing disrepute upon both the judicial and the bar. See court case cited. For example, the court observed that the defendant's online posts, while related to an ongoing proceeding, were mere unprotected public denunciation of the plaintiff. Furthermore, even though certain pre-litigation activity is protected by the litigation privilege, albeit not Blake Lively's, such protections only apply when litigation is seriously considered. See court case cited. While Blake Lively is likely to point to her now pending lawsuit in response, the Wayfair parties allege and maintain that Blake Lively never intended to file a civil lawsuit, which would have triggered the Wayfair's party right to discover. Blake Lively did not ask the CRD to investigate Wayfair. She requested a right to sue and then did not sue for weeks. As alleged in the FAC, Blake Lively's pre-litigation communications therefore did not relate to litigation that was being contemplated in good faith. See court case cited. And although Blake Lively may contest the Wayfair party's assertion whether a pre-litigation communication relates to litigation that is contemplated in good faith and under serious consideration, it's an issue of fact. Blake Lively's litigation privilege argument cannot be considered on this motion. Section 5. The SA harassment privilege does not apply. Section 47.1 of the California Civil Code, or what Blake Lively calls the SA privilege, protects a communication made by an individual without malice regarding an incident of SA, harassment, or discrimination. California Civil Code 47.1a. We are going to end part 4 right there, and we will be coming back with part 5 very shortly. Make sure you guys like, share, and subscribe. Share your opinions below. Tell me what you think of this court mess with Blake Lively and Justin B. Until next time, be safe and enjoy your day. Bye, guys.